let me say welcome to all of you. It's a pleasure to have you join our webinar today, Clarity on Chain, where we're going to be looking at legal questions on tokenized collateral in derivatives markets. This is actually the first in a series of webinars that we're developing. And our goal of these webinars is to really do a deep dive into the specific legal questions around tokenized assets. That's something that we've received a lot of interest from members on. And so our hope is that by really diving into these assets, asking legal questions, we can help all of you out there to figure out what questions you need to be asking and also get some of those answers. My name, for those of you I haven't spoken to before, is Mark New. I'm co-head of digital transformation and senior counsel at ISDA. We have a great lineup of speakers to go through our questions today. Tom Sullivan is a managing director and head of digital assets at DTCC. Brandon Hammer is a partner at Cleary Gottlieb. And my colleague, Marcus Hunter, is counsel at ISDA. Marcus and I will be asking the questions, and Tom and Brandon will be providing the answers. So before we jump in, let me just say a few words about what ISDA's been doing in this area and how these webinars relate to that. I would say that we've seen interest from members in the benefits of tokenized assets for collateral going back several years now. We actually did some projects in 2023 and 2024 where we started to consider the legal aspects of tokenized collateral. And what we did there was to develop some model provisions for a variation margin CSA to allow people to make the updates necessary to post tokenized collateral in accordance with the CSA. And then related to that, perhaps the more interesting question in some ways is what would the updates that would be necessary for our legal opinions for collateral to make sure that we would be able to explain to counsel what would need to be covered in legal opinions and understand the differences for tokenized collateral so that the legal opinions would cover the relevant questions. And what we learned from that work on tokenization was really the importance of understanding the specific legal structures involved. It's really necessary to get into a fair amount of detail to understand the legal rights that the structure provides, and that then drives the collateral analysis, both from a documentation perspective and from a legal opinion perspective. And as part of that work in the collateral guidance note, we developed a taxonomy identifying certain features of different types of tokenized assets that would be relevant for documentation and opinions. Fast forwarding to today, I think we're in a really exciting time because now we're starting to see a number of assets on the market where there is sufficient clarity, sufficient documentation for us to really delve in and ask the specific questions around the way the tokenization structure works. And I think it's because of that we've received increased interest from members in this area and why we're starting out this series of educational webinars today. So we want to make these webinars as useful to you as possible. We would certainly appreciate any questions coming through the Q&A feature in the webinar. So definitely use that and send us any questions you have as you go along. We'll also be recording today's webinar and we'll be circulating that afterwards. And so if you have follow-up questions or ideas for future sessions that you'd like us to cover, please do get in touch with us and send us your thoughts and questions. So with that, I'm looking forward very much to diving in today and looking at the really brand new DTC offering. Very exciting. So just to kind of help us set the scene, I'm going to pose a series of questions to Tom, first of all, just to really explain how the system works and what we're looking at for people who may not be familiar with it today. So let's start off with a general question, Tom. Can you give us an overview of DTC's tokenization service and touch on what benefits it offers?
Sure. So maybe firstly, I'd just like to say thank you to ISDA for having me here, and really thank you for all the work that you've done over the years. There are many of us who've been at tokenization for some time, and we really are at an inflection point, I believe, and with the work that we're doing, which we'll explain today. And we wouldn't be able to achieve these things without the support for the community and looking at what not only tokenization can do, but how it can be used, and collateral is certainly a key use case for us. So in terms of the tokenization service, and the other thing I'll say is I'm so glad that there are a bunch of lawyers on the phone, so I don't have to answer the hard legal questions. So I'll just answer the fun questions, I think. But so the tokenization service, and maybe just as a bit of a background, a couple of things. DTCC made an acquisition of a company called Securities about a little more than 2 years ago. And through that acquisition, we acquired the technology that enables tokenization. There's a suite of services that Securities had. And when they came aboard, they really made the bold proposition of what now that we're on board, what can we do? How about let's tokenize all the assets that sit in the depository to the tune of 100 trillion worth of assets, which is what we hold. And in going through the process for the past couple of years to do that, we looked at, and I know that we'll talk about the no action letter that we received and the details there, but really at its core, what DTC does today is we are the holder of record for most U.S. assets, U.S. equities, and corporate bonds, and we operate a closed system that's member-based, participant-based. That DTC is the holder of record with a transfer agent. We have a closed system. We can have participants, and then the participants maintain their own books and records where they show the holders, the individual holders on their books and records. What we've in using this tokenization model, what we're now able to do is enable participants to take the assets that sit in their depository account and create what we call a conversion order, which is moving it from their DTC account into an open network. And we'll talk, I'm sure, about the type of networks that we're looking at. And when they do that, it enables that asset to be then available on chain in a way that's at the discretion of the participant. So that means that the participant can define the types of wallets, the wallet structure that they use, whether they maintain assets in omnibus form or individual form on the blockchain, and importantly, enables the utility that smart contracts on blockchain can do. And in terms of the benefits that we see, there are many, and we're really just at the early days. Certainly, the mobility of collateral as we move towards more 24/7 markets, as we move to a greater intersection between traditional markets and crypto markets, we will see the need for those assets to interact in a more seamless way, which they don't do today. And that's really what we're building towards.
That's great. And just for people who may not be so familiar with the terminology, could you just say a bit about what it means to have an asset in a wallet in the service?
Sure. So, and again, what we have today is we maintain our own books and records, and we have an account structure where we maintain accounts for our participants. A wallet is a place on a blockchain where it's the assets sit, but importantly, there are two sets of keys: there's public keys and private keys, and in controlling the assets that sit in the wallet, you're doing so by controlling the private keys that, whether the individual holder or the holder of that wallet maintains, and enabling those private keys to move assets.
That's great. So we now have this system where assets can be held as tokens in wallets. Who's that available to? Who can use this new system?
So as I mentioned, the starting point is it will be available. The tokenization service will be available to our members and participants. So there's several hundred firms who are participants in DTC, primarily U.S. banks and broker dealers. But what it does do is that those members and participants are allowed to do the initial tokenization, but in having the assets available on global blockchains will enable international holders to have access to those assets in a different way, meaning through the wallet structure and having the greater mobility across chain, as opposed to staying in the account structure and the closed system where we're maintaining assets in the current form.
Great. And I've already mentioned that we've been very interested in tokenization from the collateral perspective. How do these tokens tie into the collateral world, do you think?
Sure. So when we think about the types of assets that we're describing, and as I mentioned, DTC primarily is the holder of record for U.S. equities. And I know we will talk about more about what's in the no action letter, but in terms of the scope of the types of assets that we have that will be available, will be U.S. equities, meaning the Russell 1000, major ETFs tied to major U.S. indices, and then U.S. Treasuries. So interestingly, U.S. Treasuries is not a natural place that DTC normally engages. Most of those assets sit in the Fedwire and at banks, but one of the main points of feedback that we've heard from our clients and we see in the market is U.S. Treasuries are clearly used in financing and in collateral management. And so by enabling the access to U.S. Treasuries, we believe that there's that's a gateway to doing the collateral management. But it's as I said earlier, one of the drivers is really the move towards the 24/7 markets, the full 365 all year round access, as opposed to having limited access to during the banking hours and settlement windows, but also really the use of smart contracts. So smart contracts are programmable tools that really make decisions or enable for decisions to be made through a greater deal of automation, so that assets can be moved. You can think about having some elements of your agreements or your MSAs and things like that embedded in a smart contract, so that the collateral can be moved more efficiently. And that's among the things that we're expecting to see. And then the last thing I'll say is, as I alluded to earlier, with respect to the interoperability or the interaction between traditional assets and crypto assets, what we've seen and what we are seeing and we've heard from the market, and in fact, we demonstrated this last year, what we called the Great Collateral Experiment, where we had native on-chain assets, whether that be stablecoins, whether that be tokenized money market funds, whether that be crypto assets like Bitcoin, and then tokenized assets in the form of U.S. Treasuries and things like that, and showed that they could interoperate and interact together, so that you can use non-traditional assets as collateral, you can move traditional assets versus stablecoins, you can do payment versus payment activity where you're moving a traditional asset in token form versus a crypto asset. So all of those things are become available by leveraging blockchain technology.
That's great. It's not the topic of today's webinar, but you did mention money market funds there, and I think I should, mention for the group that there is an ongoing project. There was one being done last year looking at money market funds. There's an ongoing project between ISDA and GDF looking at money market funds in a US context. So that's definitely an area of interest for us currently, and we'll come back to that later in the webinar. So you mentioned the pilot program, the no action letter a couple of times already. Perhaps you could talk about that and what's the regulatory aspect here?
Yeah, sure. So obviously the SEC is our primary regulator, and the SEC has been quite engaged over the past year plus in having the market be more proactive in looking at how the market can adapt to technology. So rather than being passive, they've been clearly more proactive in both creating rules and creating some guardrails as to how the institutions and the market more broadly can operate. And so typically when DTCC engages in any type of new activity, we are required to go through a rulemaking process, and we have there's a bunch of steps that we need to do to make sure that we're complying with every law, we're complying with our rule book. And what the no action letter is allowing us to do, so it's a 3-year period where we can operate this service without having the full set of rule book created. And it will enable us, obviously we intend to do this in a safe and sound way, but enable us to do it in a controlled way, so that our assets can be made available, that we will control the assets from end to end, and we can exert control from end to end to demonstrate possession of control, which is a key tenet of what we do, but also to then allow us to move the market forward without having to go through that full rulemaking process. So we're expecting that at the end, when we have some learnings and we get some some real activity on chain, then we can move to doing this in a more formal way and make it so that it's permanent. Yeah. And as I mentioned, just in terms of the assets, it's scoped in a way that encompasses the Russell 1000. So really, it's focused on liquid assets, on ETFs tied to major indices, and of course U.S. Treasuries, so that it wouldn't be some obscure asset or a real estate trust or something like that. It's really things that were expected to be liquid and the market would intend to use. And then maybe the last thing I'll say along the lines of how we do this, and I think we'll probably talk about this a little bit later as well, is that because DTCC is creating the set of smart contracts on each blockchain, within those smart contracts for these assets, we are allowed to do certain things, meaning that we're enabling our participants to mint the asset, of course, burn the asset when they come back in its traditional form. But there are other protections that we have where we would have the ability to freeze the asset if there was illegal action or some type of sanction activity, and seize the assets and bring them back into the depository if need be for whatever reason. And that really extends that concept of possession or control. So DTCC still maintains the actions that it does as a depository.
I would commend, by the way, to the listeners, the DTC letter and the SEC relief. It's a really good analysis of some of the issues in this area. But one of the things that I picked up was that the service will operate on multiple blockchains. And in the past, one of the questions that we've seen in the world of digital assets more broadly is things like the risks of bridges, what happens when assets move between chains. So how does DTC think about operating on multiple chains in this area?
Yeah, so there are a few things that are in play and how we look at it. So one is, of course, market demand. So we take feedback from our members and our participants. We look at where the market is and has evolved with respect to assets on chain. And again, whether that be things like tokenized money market funds, stable coins, and then activity on crypto assets. And so along those lines, so the first chain that we announced to being live on is the Canton network. And the driver for the Canton network really has been that there's a strong push from our members and the large group of market participants who have been active on Canton in some way. And so really that's just, we're moving in the direction where we believe the market wants to go. But we understand that there are other options, and it is in some ways early days. We're not fully live yet. We do have a process of how, so we want to be open and agnostic to a degree, but we do have a process of vetting blockchains that meet certain standards. And you think of things like resiliency, uptime, types of, I would say, negative impact, negative events like financial crime, and we take those factors into play when we do this evaluation. So there's some inputs from the market, from evaluation, and then there's also a review, and then of course we will need to prioritize how we build to each network. So we're going to do that in a measured way. We expect that there will be a rollout over time of not 10 chains at once, but more like one or two at a time as we feel comfortable that we've built the connectivity in the right way.
Yeah, thank you. You mentioned earlier like the control and the mint burning process. Again, some new terminology right in this area. Perhaps just explain mint burn, and then does that help in other sort of exceptional cases? Like you mentioned the private keys before, and one thing that people may have read about is people, and perhaps in the Bitcoin context, losing the private keys. Is that a risk that you guys think about?
Yeah, so absolutely, and that's in fact, so minting and burning is really, a mint is just a creation of a token on a network, and the burn is the removal of the token on a network. And so with respect to there's a range of conditions where we may do a clawback or burn or freeze and or remint, and one of them would be with the loss of private keys, where you can look at a circumstance and the fact that DTCC controls that, has access to that smart contract. It will enable us to do a remint if there was if that was necessary, and that would really mitigate the concern, again, because the original asset, even though it is the same QSIP, the same entitlement rights to the underlying asset still does sit in the depository. And from the transfer agent perspective, DTC is still the holder of record. So that really gives the option of having the mobility and flexibility you have on chain with maintaining the security and control that you expect from a depository being involved.
Great. And then you mentioned this is like there's a pilot phase going on, right? So there's a timing angle to this. Perhaps you could say a bit about what you see as being the phasing of this project.
Yeah, so we're expecting to have our first launch in early Q3, and that first launch will be limited in scale, both in terms of numbers of assets and numbers of participants. We'll do it will be a live pilot, and it will be, doing it in a way that we make sure that everything happens appropriately and in a controlled way. From there, our participants will have more access to our testing environments throughout the summer, and then we're expecting a phased rollout from into the fall, so October, and then beyond towards the end of the year. And through that phased rollout, we will increase the amount of assets that will be available. So on day one, it will be a very narrow set of assets, just to verify that the process works in production. And then we will add the numbers of assets, meaning that we won't go from 0 to 1,000. We'll probably go from 0 to 20 and 100 and then beyond. And again, really just to maintain that control framework, to make sure that everything's working properly, so that volume can be scaled in a way that's controlled, and that our members have, and the market has the opportunity to both see how it works, see how things interact, develop their frameworks and structures, because we really are doing this in parallel. What we're building and the market is building, again, wallets and policies and procedures and all those kind of things that need to be done. So it will happen over time, gradually throughout I would say the end of Q3 towards the end of the year. And then from 2027, we really expect to ramp up.
Very exciting. That's great. Well, I think that gives us a really good scene setting for the second part of the webinar. So thank you very much, Tom. I'll just remind the group, if you do have any questions, please do use the question function, the Q&A, send those in, and we will do our best to answer them. So for the second part of this, I'm going to hand over to Marcus, who'll be doing the deep dive on the legal questions.
Thanks, Mark, and thanks everyone for being here. Tom, that was a fantastic overview of a really exciting project, and we're looking forward to discussing it. But we can't go any further without talking about the legal framework that is going to be applied and some of the legal questions that have emerged from tokenization taking this industry by storm. For that discussion, I'll be talking to Brandon Hammer from Cleary Gottlieb, and I think a good place to start is setting the scene on what the traditional legal framework of setting like DTCs under U.S. law would be. Sans tokenization, what would the traditional legal framework applied to DTC look like, Brandon?
Sure. Thanks, Marcus, and thank you for inviting me to join you today. So the main principal legal framework that governs DTC's holding of securities is Article 8 of the Uniform Commercial Code. Basically, when a clearing agency like DTC acquires a security, credits it to a securities account for a customer, under the UCC, it is treated as a securities intermediary, and the customer is treated as an entitlement holder. That has a number of very important legal implications. First, it means that DTC as a securities intermediary is subject to a number of specified duties. This includes the duty of DTC to hold those securities on a one-for-one basis. If it credits an Apple share to a participant's account, it has to hold an Apple share corresponding to that. It has to listen to transfer instructions and certain other instructions of the participant. It has to process distributions, listen to voting instructions, things of that sort. It's one set of implications. Another big set of implications is that Article 8 sets forth the perfection rules and the take-free rules that we have essentially come to rely on as just kind of common sense. The first is that you can perfect a security interest by control. In particular, if I want to pledge my securities to you, Marcus, I can effectuate that pledge by having the securities transferred from my account to your account such that DTC recognizes you as the entitlement holder. Alternatively, we could do a control agreement or another arrangement to establish control. But one very easy way to establish control is for you to become the entitlement holder, to have the securities in your account. In addition, take-free rules under the UCC establish that if you become the entitlement holder because you've purchased the securities from me in good faith for value, you cannot be exposed to claims of my creditors or the person I acquired the securities from creditors saying, oh, these were actually my securities because 18 transfers earlier, someone stole them from me. You acquire legal certainty that you have those assets. And then finally, Article 8 sets out clear-cut ownership and insolvency rules in that if DTC were to become subject to an insolvency regime, those assets would not form part of DTC's estate, and instead they would be reserved for DTC's participants as the entitlement holders. That's the legal framework as it exists outside of tokenization and on which kind of the industry has been operating for quite a while now.
Great. And I think it's important to note, obviously, that that's the largely the U.S. legal framework. I think as we've discussed before, Article 8 is almost assumed to apply everywhere. It's on a state-by-state basis, but that is the overall U.S. approach. Obviously, with our international focus, there are different jurisdictions with different questions, and I think we'll address some of the conflicts of laws questions that emerge later on in this webinar. But for now, let's focus on, we have our jurisdictional framework here, the U.S. jurisdictional framework under which DTC is operated up until now. So based on that legal framework, what changes when assets and transfers at issue are tokenized and on-chain as under this pilot program?
The short answer is nothing. The way the framework works outside of tokenization is that DTC records who is the entitlement holder to the security, who's its customer, who's the owner of the securities using central books and records. All that happens with tokenization under this framework, under the framework that DTC developed, is that recordation happens using a different system, using distributed ledger technology. But the nature of the relationship between DTC and the participant remains the same. DTC remains the securities intermediary. The participant that has the registered wallet where the token is held remains the entitlement holder. All that is changing is the record-keeping methodology, and just changing your record-keeping methodology does not change any of the legal analysis applicable to that relationship. So you can still perfect the security interest by acquiring control, for example. It's just you acquire that control by moving the token from one person's wallet to another person's registered wallet. You still, in that case, will benefit from the take-free rules, and you still benefit from the insolvency and kind of distributional rules under the UCC. In addition, all of the duties that apply to DTC to ensure that they hold on a one-for-one basis, that they listen to your instructions, those duties continue to apply as well. We just have what we call fancy books and records.
And to analogize to a previous sort of shift of record-keeping structure, a record that is kept on paper and transferred only on paper versus a record that is electronically recorded. Those two things are both still record keeping and would both still be recognized. Just as this is sort of a technological step forward, it's not necessarily a break in the legal framework. Would you say that's
Yeah,
correct?
I think that's a fantastic analogy, Marcus.
Thank you, Brandon. That's what I'm here for. Fantastic analogies. So given that DTC's program will fall under the same legal framework, how are the traditional legal concepts handled when transactions are on chain? I'm going to run through a few of these. I imagine that largely many of these will stay the same, given that the record keeping has changed technologically, but not fundamentally legally. But I have a feeling we'll get a number of questions on these. And so to discuss some of these beforehand, we can sort of head off some questions and also get into where there might be discrepancies, if there are any. So first of all, and I think a fundamental issue here, documentation of token holder rights. Does anything change under this structure legally?
Yeah, it kind of at a macro level, no. And anytime you have a relationship between a securities intermediary and its entitlement holder, you document that in a contract. The general contract right now is DTC's rules. There will, however, be a specific agreement that participants will sign relating to the tokenization service. So there will be different contractual terms applicable to the relationship, but the idea of having that relationship governed by a contract and that contract kind of dictating the key terms is the same. It's just a different contract for the tokenization service.
Great. Change of contractual framework, but not of overall framework.
Exactly.
So secondly, segregation of customer funds. Obviously, we're dealing with wallets here, which, as Mark and Tom went over earlier, are a different concept than pure accounts held with DTC. But is there going to be a need to segregate funds in different wallets? How does that work under this structure?
Yeah, so I think the short answer there is no. When DTC when a participant has a token held in their wallet, a tokenized entitlement in their wallet, what that means is that DTC is saying, hey, I hold this security for you, intermediary. To the extent that for you, participant, to the extent that participant is required to ensure that the securities it's holding for itself are in a separate location from the securities it is holding for its customers, then absolutely, in that instance, it would need to use separate wallets for its own securities and for the securities it is holding for its customers. Just like today, a number of participants will use one of DTC's segregation arrangements to ensure that some of the securities it's holding in its proprietary capacity are not commingled or otherwise somewhat segregated from the securities it's holding for its customers. Likewise, on-chain, participants may, if their regulatory obligations demand it, use separate wallets for their prop securities and securities they hold for customers. They may also decide to hold securities for individual customers in particular wallets. That I may say, hey, I want my securities held in a separate wallet from others, and the participant could do that as well, but they would do so in accordance with their regulatory obligations. I think it's notable in this respect that something that's not in the no action relief is any relief from Rule 15c3.3. And that is because I think we're all confident that relief from 15c3.3, the broker-dealer customer protection rule in the United States, is not necessary. Again, for the same old trope that the nature of the relationship hasn't changed. DTC remains the custodian of these securities. The securities remain held with a clearing agency. And so to the extent when you have your securities in your regular participant's account at DTC, it satisfies 15c3.3. So too does it satisfy it if you have the securities in a wallet, in a specific wallet on chain through this program.
Great. How about establishing ownership of an asset, a tokenized asset here? Is receiving the token in your wallet sufficient to establish ownership, holding it, any other element? Obviously, the elements stay the same under this framework, but do they need to be proven differently? Anything change?
No, it's pretty much the same. It's pretty much just that you need to have the token in the wallet that is registered to you with DTC. And once you have the token in that wallet, DTC's ledger scan system will say, "Hey, that token is in that wallet. That means that you are the entitlement holder of that security." So all you really need to do is have the token in your wallet.
So, related question. I'm glad you brought up Ledger Scan, which is the technology that sort of makes the change by observing where transfers have happened. You can talk a little bit more about that, and Tom, if you want to mention it as well. But is that off-chain transfer scan update required to? Is that a precondition for verifying legal ownership?
Yes, that step must happen because DTC makes clear that its source of truth, its books and records, is LedgerScan. However, I will note LedgerScan is operating on a continuous basis, and so is constantly scanning to see where the tokens are. Therefore, when LedgerScan identifies that the token is held in my wallet, at that moment, which will be at the moment the asset lands in the wallet, DTC's books and records will reflect that I'm the owner.
So LedgerScan is reviewing DLT, and making changes based on that, but with a step removed. So if there's an issue with the underlying technology, it's not purely reliant on that, and there's a level of remove from the underlying technology.
Yes, I think that's a fair description.
Great. I want to turn to something that Mark and Tom discussed briefly, which is the mint burn issue and just the legal aspect of that process. So if a token is transferred in error, whether it's a technical error, user error, what have you, we've all made them. Does DTC have the power to burn and mint a new token? Obviously they do, but what sort of legally backs up that legal right?
Yeah, no, that's a great question, and it's kind of the same analysis where if DTC makes an erroneous paper entry or a participant requests an entry that's an error, or there is some sort of error with DTC's electronic spreadsheet, what's the legal framework for adjusting that? And the legal framework is that a custodian, a securities intermediary, upon learning of an error, is permitted to make an adjustment to reflect that error. And so that is the same process where if a participant inadvertently transfers the token or loses the private key, then just as if I mistakenly send a transfer through a centralized book and record, I call my custodian and say, "Whoops, I made this mistake. Can you undo it?" And then the custodian can undo it. Again, these are just DTC's books and records, so they can make that change just like any custodian can.
Great. I want to circle back to something I asked previously, just about timing of the transfer of ownership under the transfer scan issue. So just to make 100% clear, the ownership being verified, the transfer being verified by transfer scan, that's the moment that legal ownership is established, correct? Not when it happens on chain necessarily.
That is correct. Although
even though they happen,
I think that's a bit of a distinction without a difference because they happen at the same time.
Yeah. Operationally, it's going to be simultaneous, but the actual legal moment is transfer scans scan of the transfer.
Yeah.
They chose a great name. Describe exactly what they do. So now definitely jumping gears to the conflicts of laws issue that I mentioned above. How is this structure impacted by conflicts of law? A token holder who's in one jurisdiction, who's covered by that jurisdiction's law, it might be looking to local law over the U.S. framework that you've laid out here. How does that impact DTC, if at all? And importantly, also, how does it impact the participants in DTC's program here? Because as we've discussed, this is going to be more about DTC's participants offering these wallets as well and overseeing the transfer of the tokens that they've set up. So there's a few steps of remove there. Can you talk through how those might be impacted by different jurisdictions applying different law?
Sure. So if I hold securities with a securities intermediary, if I hold securities with DTC and then a legal dispute arises in the United States, in France, in England, in Japan, what the court's first role in that dispute is going to be is decide what law governs that dispute. And helpfully, in the context of securities held with an intermediary, there are, in many jurisdictions, relatively well-established and clear-cut choice of law rules for questions like perfection, priority of security interest, ownership rights, things of that sort. Those rules typically look to where the custodian is or where they maintain their securities, or where or what they designate as the governing law for the agreement, their custodial agreement. To the extent that is the relevant choice of law rule, those same choice of law rules will apply to the tokenized entitlement no differently, because the legal nature of the relationship has not changed at all. So if you are in a jurisdiction that relies on the PRIMA framework in Europe, and you get comfortable using that framework, that New York law will govern perfection of your security interest or your ownership rights, the fact that you're using a tokenized entitlement doesn't affect any of that. That's at the participant DTC level. I think it's really important, your question, Marcus, on kind of how does it work at the level of the participant and then its customer, to kind of take a step back and talk about the nature of that relationship. DTC, of course, has only a relationship with its participant. It does not undertake any relationship with the participant's customer. If the participant wants to allow that customer to benefit from the tokenization arrangement, it has to reach an agreement with its customer on that arrangement. In particular, they have to agree with the customer not only, hey, when can I transfer this token, kind of what are the requirements before I can effectuate a move, but also what it means as a legal matter for the customer to have the token in a particular wallet, or for the customer to transfer that token. The most straightforward thing, at least from a U.S. perspective, would be for the intermediary, the participant and its customer, to reach an agreement similar to that which DTC establishes with its participant, which is that my relationship with you isn't changing, but we're now using an alternative record-keeping system. Assuming they do that, then again, the legal analysis, including the choice of law analysis, should be the same legal analysis that applies when those folks are holding securities under non-tokenized frameworks. If I hold a security with my broker and a dispute arises from that, and I go to a court in London, that court is going to apply the choice of law rules. They'll see, oh, this is a security held in New York under a New York law agreement. Therefore, we will apply New York law to this. And if that is the case in the nature of the relationship between the customer and the participant, again, the fact that they're using tokenized software to do this is not really going to make much of a difference. Should they instead choose to apply a different law to their relationship, then those choice of law rules may well point to that other law, and then you'd have to do an analysis of French law or English law, what have you.
Great. Thank you, Brandon. I think we have a few final questions before we launch into the Q&A. So Tom and Brandon, feel free to speak up. These are bigger picture and looking forward to both where this framework is going and other legal questions surrounding tokenized assets. First of all, outside of the DTC model, what concerns, if any, do you have about any legal uncertainty that still remains around tokenization? Are there any hiccups you foresee? Obviously, the legal framework is largely going to stay the same, new record-keeping systems, but any hiccups you can imagine occurring there?
So I would say outside of the DTC structure, I think for any tokenization arrangement, it's critical to do a careful analysis of what the legal structure for that relationship is. What is the issue of the token saying and agreeing the token represents, and how does that comport with applicable law? I think some tokenization arrangements, like the DTC one, the tokenization does amazing things as Tom described, but it's legally a little boring because you're preserving the legal relationship. By contrast, sometimes when folks issue a token, it's an entirely separate instrument. It could be a derivative, it could be a note, and that presents an entirely different risk profile from a regulatory perspective, from a commercial law perspective. And I think what's super critical and what worries, what can cause agita is to make sure you actually look at what that legal relationship is and ensure you're comfortable with that legal relationship.
And maybe just from a practical standpoint, if I chime in, there's other models that, as Brandon said, there are a variety of models, and one you can envision where there's a direct issuance of an asset on chain, where the rights, there's a transfer agent that creates the asset directly on chain, and in some ways, our model and the way we look at our model is continuing to address the problem we solved 50 years ago when there were transfer agents issuing directly, maintaining books and records. There is a direct registration model that exists today, but the market has spoken in a way that our model, 99% or so of the assets are under our model. So while there are definitely other ways to explore things, we did this thoughtfully in a way to maintain the good things that we've done and established over the 50 years and get the benefits of enabling blockchain and smart contracts.
Great.
Yeah, Marcus, while you've been talking to Brandon there, we've had a lot of good questions come in. So I think I've been trying to theme them up in my head, and I think I'll just kind of start by trying to fill in any gaps that might have been there from what Brandon was saying. So just, I think, a quick one. This is, could you, when you say that holding a token in the wallet establishes the ownership, is that by operation of US law or the result of a contractual framework established by DTC?
It's kind of both, because under the contract, DTC agrees with the participant that if you have this token in your wallet and we identify that you are therefore the entitlement holder. If you are the entitlement holder to the security, then under Article 8 of the UCC, all of those duties, protections, and provisions that I described apply. So it's the marriage of those two, I would say.
Okay, that's great. I think we already covered, there was a question, by the way, about location of assets. And I know this has obviously been a big question in, other kinds of digital assets, crypto assets, on permissionless chains. And the question was just, how is the location of the assets determined? I think you gave a great explanation, Brandon, as to what the rules are. I just want to say that I think in this area, terminology can be a little bit tricky. I hear about people talking about, do you hold the physical asset? What's the location of the asset? And in some of these areas, I think it's important to note that, as described in our collateral legal opinions, often you're talking about applying things by analogy. So we have a deemed location of an asset that gives you a conflicts of law rule that tells you which rule you are, or which jurisdiction's rules you're looking at to determine questions like how does perfection, transfers, ownership work. And I think you described that really well, Brandon, but anything you want to add on top of that?
Yeah, I think as you were saying, Mark, kind of where the token itself is basically the same thing as saying, well, where are my records located? And so in general, where the particular location where you have either your main records or your backup records is not really that important. What matters is kind of all of the other pieces, where if you're holding physical security certificates, where those are held, what jurisdiction you have agreed is kind of your jurisdiction as an intermediary, what law governs your agreement, kind of where a record is located is normally not relevant.
I think we've touched on these, but perhaps we can just fill them in. So to Tom, there's a couple of questions on the service. Will access be limited to members and participants, or will there be indirect participant access? Perhaps we could just explain again how that could work for non-participant members. And then is there a plan for adding other types of debt, e.g. agency debt or senior unsecured corporate bonds, to the list of tokenized assets?
So again, with respect to the model, the first point of access is our participants. And so the participants are the ones who control the tokenization of the assets, meaning, or they drive the tokenization. They have the direct access to the tokenization service, and it is connected to their participant account. That said, in terms of and this is maybe something we didn't talk about in too much detail, in terms of how their clients or the participants' clients use the assets is really then determined to some degree by the participant. And what I mean by that is the wallet structure that the participant defines. So we rely on our members, and this is why we're doing it this way with the first point of access is our participants, because of that we have this membership agreement already in place. We have a vetting process for our members already in place, and we rely upon them as we do today to validate their clients our participants do their own KYC. We don't KYC the underlying clients, and we expect that to continue. What we will do is we maintain a whitelist of the wallets. So when a participant comes to us and says, here are the wallet addresses we want to use, we rely on their due diligence and accept that and then create the whitelist based on the wallets they have. That wallet structure can be done mirroring the systems today, meaning an omnibus wallet that the participant controls and has all the assets that both their clients have tokenized. They can maintain individual wallets per client or per account. They have the discretion to do that. So, and potentially in those cases, the participant controls the keys. But that's the distinction, that if they use that second option, meaning that they have individual accounts or individual wallets for their customers, then that's where the underlying client has direct access and visibility to their assets on chain and can potentially make the instructions, again, as defined by the operating model that our participants employ.
Thanks, Tom. And anything to add on the sort of potential expansion of the types of assets that could be in the program?
So in terms of expansion of assets, in order for us to add assets, we would need to go back to the SEC and ask for additional exemption. It's certainly possible, so that as we see the use cases expand and grow, we are certainly open to doing that. But it would really be driven by market demand and utility. But absolutely, we would need to go through the process again, to add or amend the no action letter. But certainly, we would consider that.
Great. We've had a couple of questions come in, I think, sort of along the lines of the use of tokenized assets as collateral. So it'd be kind of worth exploring how far we can go with these. So I think I've seen two questions that sort of talk about what if there were a default by an intermediary? How would the enforcement process against the asset work? And I guess that goes to, if I've received a token as collateral, how would I enforce against that token? And then this may be a step too far in terms of complexity for this discussion, but if the intermediary that held the wallet for that token were to go insolvent, how would that affect the analysis? Brandon, what can we say there?
Sure. So the base case, let's say it's just two participants, leave aside customers right now. Marcus and I are participants. I enter into a security agreement with Marcus. I say, Marcus, I have these securities. I'm going to grant you a security interest in them, and you will perfect that security interest by virtue of my transferring the tokenized entitlement to that security from my registered wallet at DTC to your registered wallet at DTC. By virtue of that, you have a perfected security interest. The nature of the security arrangement is pursuant to our bilateral agreement that doesn't involve DTC at all. If I then default, Marcus will go and can do one of two things. He can either sell that security and transfer it via the distributed ledger technology to another participant, or he can say, look, the people I want to transfer it to, they don't want it in tokenized form. They want it in traditional centralized books and records form. He can give an instruction to DTC that says, DTC, convert this back into a non-tokenized entitlement, and then he can foreclose the same way he would foreclose for any other loan that I defaulted on involving securities consisting of that collateral. Then the question of, well, what if actually Marcus and I are customers of you, Mark, and you are holding the security, and you're holding it, let's say, in a control account, or you're allowing Marcus to hold it in a wallet that's registered to you, but for which he has the private keys, and then you go under. The principal question in that instance is going to be, what is the relevant insolvency law applicable to you, Mark, in that instance? If you are a broker-dealer member of the Securities Investor Protection Corporation, that will be the Securities Investor Protection Act, which has very specific specific provisions concerning the transfer of those securities to another broker-dealer, or the liquidation thereof and the distribution of those amounts to the relevant customers. And none of that changes. That analysis remains the same. Again, no different from if I had pledged those securities to Marcus, you were the intermediary, and we were doing all of this in the non-tokenized framework. The analysis of what happens in your bankruptcy would remain unchanged.
I'm so glad you took that question, Brandon.
Thanks, Brandon. An interesting question from the collateral perspective is under the UMR regulatory frameworks, are tokenized versions of assets recognized as collateral? Will we need to see rule changes to recognize them? I'll turn to Brandon. Any thoughts on this one?
Yeah. So first off, I am not an expert on the UMR, but I did read the CFTC's tokenized assets guidance, and what the CFTC basically said is the rules aren't different for tokenized securities as compared to non-tokenized securities. The rules are the same in that you need to satisfy yourself that you have a perfected security interest in those securities. You do that through centralized books and records, good for you. You do that through tokenized books and records, that's okay too. You just need to be able to confirm that your security interest is perfected and satisfies the other provisions of the rules. And the use of tokenized security entitlements under the DTC framework, based on that guidance, would be that you can use them to the same extent you could other centrally recorded securities. That's from a U.S. perspective. I can't really speak to the European perspective and the other U.S. regulators. I don't think the prudential regulators and the SEC have not kind of weighed in to the same extent on that issue.
Yeah, maybe if I just jump in as well, because I had the privilege of serving on the advisory committee that made the recommendations that the CFTC ultimately adopted. And really the message that we conveyed to the commission in layman's terms was the wrapper doesn't matter. The underlying entitlements stay the same. And as long as you have those underlying entitlements, the fact that it's in a token wrapper should not matter.
I see we're coming almost up to time, so I think we will have to leave the Q&A there. We still have some questions that we weren't able to get to, so apologies for that, but we will follow up where we can, where we have the names for the people who submitted the questions, so look out for a response from us from that. Marcus, I'm going to hand it over to you to take us out.
Thanks, Mark, and thanks everyone for joining. We're really excited to have kicked this off, and Brandon and Tom, thank you so much for being here. You're both provided a wealth of knowledge for everyone, and hopefully everybody's feeling a little more comfortable wading into this new world. Our next iteration of this webinar series will be in late April. We're going to have two wonderful guests, just like these wonderful guests. Ed Ivey from Haynes & Boone and Henry Stiles from Franklin Templeton will be joining us to talk a little more specifically about tokenized money market funds, which are an asset I think everybody is really interested in, especially as potentially eligible collateral if we can make it all work together. More on that, and look for that invite coming soon. Thanks, everyone. We really appreciate your attendance and your great questions.